Have you recently been arrested or charged with a criminal offense in California?
Did you know that your employer cannot automatically terminate you after you've been arrested?
Even if you have been convicted, do not despair. You have options and you do have a way to clear your criminal record. Hello, my name is William Pernik. I'm a criminal defense attorney and a founder of the Pernik Law Firm. And I'm really excited today to be joined by Miss Ashley Cameron, who is not only our in-house counsel and research attorney, but also someone who has experience in both criminal law and employment law. For the past 6 years, Ashley has worked for a law firm that specialized in advising employers on what to do in many circumstances, including dealing with employees who have had criminal allegations or arrests. And she's here to offer a unique perspective of an employment law attorney on what to do if you or someone you care about have been arrested, are worried about losing your job, or are going through a workplace investigation. Please stay tuned to the rest of this video, where we're going to provide you with a helpful list of suggestions, things you can do in order to protect yourself, not only in a pending criminal case, but also with your boss. Ashley, hello. Thank you for joining us. I'm really excited to have you here talking to our viewers about your unique perspective as someone who spent the last 6 years advising employers, especially big firms and corporations and institutions like school districts and banks and large firms on what to do when you have an employee who is charged or convicted of a crime. Ashley, usually when I get a phone call from someone who had just been arrested, just posted bail, the number one thing they are concerned about, of course, is, will I go to jail? Am I going to get convicted of this thing? But the number two question I almost inevitably get is, what do I do with my job? What do I tell my boss? Are they going to fire me? What will happen to me? Because I need money to live on, to pay for this. What's next? So from your unique perspective as someone who used to advise employers, what are some of the things that employers are allowed to do when they have an employee facing a criminal charge?
So employers are allowed to ask employees questions about their pending criminal case.
Ooh, that makes me really nervous. What if they say something that's going to incriminate them later? Can employers share that information with the police? Is there any confidentiality there?
Absolutely. That is definitely a concern that employees should be wary about when answering employers' questions. They should answer questions up to a point you don't want to overshare. An employer is not entitled to attorney-client privilege information, anything that isn't necessarily public record, but information that is public record, like the specific of the charges, what the court dates are, how maybe that is going to affect an employee's ability to go to their scheduled shifts. That's something that an employer is allowed to ask, and an employer can put the employee on an administrative leave pending the resolution of the criminal case.
Okay, so let's take it in a methodical order. Number one, you said they are allowed to ask an employee what happened. Is the perspective one of satisfying employers' curiosity about every morbid detail of the accusation? Or are we talking about just kind of learning generally what's going on, how that affects the operation of business, or scheduling other people around person's court obligations? What's the appropriate scope of the inquiry here?
Yes, so employers can ask questions related to how the pending criminal case affects the person's job. So an easy example is if a person has a job that is directly related to driving and a person has been arrested for a DUI and their license an issue in some way, then obviously an employer has the right to ask about that and see if that criminal case is affecting their ability to do their specific job duties.
Well, let me ask you an example based on that. What if, for example, I work in a warehouse and I can use public transportation, I can show up for all of my shifts, and my DUI happened when I was off the clock on the weekend, has nothing to do with my job. Can an employer fire me for that?
No. An employer cannot fire any employee with a pending criminal matter. They cannot make any kind of unilateral employment decision until after a conviction has been made. But that's a great point. During the course of conversations with the employee should bring up those types of relevant mitigating circumstances that explain to the employer why their criminal case has no effect on their job.
And then when you advise an employee in these circumstances, let's say a client of our office comes to us and says, my boss scheduled an interview with me after my DUI arrest. What's the advice you give them? Give them just enough to educate about the situation, but don't go into the details. Do not appear uncooperative, but in the same time, don't give up too much detail. How do you guide a person through that?
That's exactly right. You want an employee to answer the questions that the employer is asking, so you do seem that you are cooperating, because a little kind of loophole that employers have is maybe they're not going to fire somebody because they've been arrested, but they can fire someone if the employee kind of shuts down and is uncooperative with the employer's questions. So they're not being fired for being arrested, they're being fired for being an uncooperative employee.
So if they are refusing to participate in investigation because they're afraid it's going to incriminate them, they are in a way facing the risk of being terminated.
Correct.
But sometimes we have situations where we have clients facing really serious or really sensitive charges. Certainly anything that has to do with children, anything that has to do with sexual offenses, crimes against family, things like that. An employer might be asking questions where an employee really does not want to participate in that type of discussion. So what do you advise then?
So then it is important to give some information without oversharing. So you do, again, want to be cooperative with what the employer is asking, but limit that type of information to the fact that you are fighting the case, that you have hired a lawyer, that there are going to be some court dates, and you're willing to talk with your lawyer in the court to make sure that you're still able to go to any scheduled shifts. But then you can just kind of not provide any additional details that they don't need to know, because again, like what you said in the beginning, this isn't going back to morbid curiosity. This is how the case specifically relates to the employee's ability to do their specific job duties. So if the employer keeps bringing the conversation back to, I'm able to do my job duties, I'm able to come to work, I'm able to make my schedule work with this, then that's what the employer really needs to know.
So for our viewers, the phrases to memorize, to commit to memory, to be able to repeat over and over if you're persistently questioned by this morbidly curious employer that we discussed is, I have been charged with a DUI, I have hired a lawyer, I have asserted my right to fight the case, my lawyer is aware that I have employment obligations and is committed to making sure that my court obligations will not unreasonably conflict with my employment obligations, and I can assure you that I remain able, willing, and ready to do all of the work that you have assigned, and this will not interfere with my duties. Would that be good enough?
That would be perfect, yes.
The other thing that I wanted to discuss with you is, what happens if there is a conviction? What are the types of crimes that somebody can be fired for? And what are the types of crimes that are so disconnected from the employer's requirements and employees' day-to-day duties that being fired for that would be illegal in California?
So it's always going to depend on the specific business that we're talking about and the specific conviction. So if there is a specific type of nexus between the job duties and tasks that the employee has and the job and the conviction, then there is going to be a business reason why the employer doesn't want that employee in their business.
So are you saying, for example, that if somebody works in the capacity of a bookkeeper and is perhaps accused of shoplifting in Macy's, an employer is going to say, I'm not going to have a person convicted of theft working for me?
Exactly, because the underlying conviction relates to dishonesty having to do with finances, and if their job has to do with finances, then the employer has a business reason why they don't want the employee to be in that position any longer.
What about if we're dealing with offenses like DUIs? On one hand, an employer could claim that if you have a DUI, you have an alcohol problem that could affect your employment. On the other hand, it may be something that's completely disconnected from your job. It could be an isolated incident. You may not have an underlying substance abuse problem. So how does that get factored in?
So a DUI conviction is rarely going to be the type of conviction that allows an employer to fire an employee. Again, maybe if the employee has a job that's specific to driving. They're a school bus driver, they're a truck driver, they get a DUI, the DUI directly affects their license and just their overall, responsibility in terms of driving. That's something where there's that kind of clear nexus. But most other circumstances, when you have a DUI, that kind of conduct in driving is completely unrelated to the employer's business and the employee's specific job and job duties. So that is not going to be enough to allow the employer to just fire somebody.
Now, what if employee has a conviction for something that the employer finds immoral or distasteful? Let's say an employer learns that this is a domestic violence incident, an employer, feels strongly that we're not going to have spousal abusers working here, can they fire you for that?
Not necessarily. The employer still has to be able to articulate how the particular charge and conduct related to the conviction detrimentally affects the employee's ability to do their job or their business. So if there isn't any sort of connection between those two, then there isn't going to be a way that the employer can fire the employee. But let's say the spouse works at the same business, then obviously there's going to be a little bit of a conflict and a reason why the employer does want to keep the employee out of that job. But otherwise, there still needs to be some sort of connection between why the employer is saying that the employee is no longer able to do this job because of the conviction.
What if the crime is one that we as lawyers call a crime of moral turpitude, meaning crime that suggests some sort of underlying dishonesty or immoral behavior? Do crimes of moral turpitude justify termination?
Not automatically. Again, this is all what they call in the employment world an individualized assessment. So an employer needs to go through an individualized assessment with a particular employee and their business and their job duties and see if the underlying conduct in the conviction has a detrimental effect on the employer's business and the employee's specific job duties. So that's where, with crimes of moral turpitude, there could be a greater argument that there could be a little bit of an issue. But again, it's not just black and white. The employer really needs to conduct a specific individualized assessment as to why they're saying, hey, we have to fire you because of this particular conduct.
And this is even though California has at-will employment laws.
Correct. Because, and see, that's where it gets a little tricky. So employers are allowed to terminate employees for any reason, but the caveat is it can't be an improper reason. So employers need to be mindful about how they are articulating the reason why an employee is being terminated, because employees who have pending criminal cases and criminal convictions do have specific rights with their employment laws. So it is important that employees understand their rights and don't just accept if an employer unilaterally fires them, and that an employer goes through the specific steps they need to do in order to decide if they're going to keep an employee or not.
Now, Ashley, you have taken us through the situation where a person has a job, gets arrested, potentially gets convicted, and the rights and responsibilities of employees and employers. Now let's talk about a slightly different scenario. What happens if a person is now trying to get hired for a job and has a past criminal conviction? What are some of the things that an individual can do to clear their record, and what happens at the end of that record clearance process?
So it is very important that after a person has experienced a criminal conviction, that they do reach out to a lawyer to try and clear that conviction, because that is a huge thing that will help a person get a job in the employment process. So after there's been a conviction, a person can file what we call a 1203.4 motion. It is kind of casually called an expungement, and I think one of the biggest misconceptions with that label is people and employees think that when they get an expungement, it literally just erases it from a person's record. But the reality is, when you've had a conviction and if you have gotten it expunged, on your record it still pops up that you had a criminal case that was dismissed.
Right, and I always try to explain that to clients as well by saying that expungement process or dismissal under Section 1203.4 is not some sort of magic eraser that's taken to your record at the Department of Justice that just wipes off the conviction entirely, because the DOJ, the Department of Justice, they still have a legal obligation to accurately report everything that happens to a person, starting with an arrest and going through a conviction and potentially a dismissal. So what's important is, of course, what is the very last entry on a person's criminal background check. And if that last entry shows that the conviction has been dismissed, then the question becomes, what can employers ask and what are employees allowed to say if their conviction has been set aside, if the court has told them, sir, you are now relieved of all penalties and disabilities stemming from your conviction, you have satisfied conditions of your probation, or we're dismissing your conviction in the interest of justice. So what are employees allowed to withhold, and what are they mandated to disclose?
So first, employers cannot inquire about an applicant's criminal history at all until there has actually been an offer of employment extended. After an offer of employment has been extended, then they can do a background check or a live scan. after they receive the report or live scan of the person's background and a conviction or some type of criminal activity does come up, then the employer is allowed to inquire about what they're seeing on the background check. But the important thing to remember is that an employer cannot unilaterally make a decision to not hire an employee because of a criminal record that shows up on their background check.
Let me ask you a follow-up question on that. So can an employer make it a condition of getting a job offer that you do the background check first? In other words, can they say, before we give you the offer, we need you to do a live scan?
Absolutely not. And actually, employers are specifically prohibited from including any language like that in job advertisements and anything that they put out when they're looking for an applicant. They can't say, must have clean record, or you can't apply if you have a criminal conviction. They are completely prohibited from using any of that kind of language.
So that sets up a prospective applicant to essentially obtain a job offer and be able to identify that the only reason why they were suddenly not hired is because an employer made a decision based on a background check.
Exactly. And going even further, the employer has to give the applicant a written notice saying, hey, we have received this background check. They have to provide the employee a copy of the background check and then say, because of this background check, you have been found ineligible or unqualified for the job. And then the employer has to give the employee the opportunity to respond in writing with details about the criminal case, with rehabilitation facts, with mitigation facts.
So it's kind of like when you get rejected for a credit application, they have to send you a copy of your credit report, give you an opportunity to dispute it, explain it.
Exactly. And that's a great time for an employee to be able to explain, hey, what you're seeing on this record, this actually was expunged. This was dismissed. You are not allowed to consider this at all anymore. Or you can present, information related to rehabilitation, related to treatment you may have gone into. You can talk about the fact that it's maybe years old and is completely irrelevant to whatever the particular job is you're applying for.
That sounds really interesting. And it sounds that a lot of people may not realize and may be holding themselves back from pursuing additional opportunities because they're afraid that people will find out about their past, when in fact the employers are simply not allowed to consider it for any inappropriate reason.
Exactly. An employer is specifically prohibited from considering expunged criminal convictions, or if a defendant went to a diversion program or did any kind of treatment program throughout the course of their criminal history. Any of those types of circumstances, an employer is prohibited from considering that when deciding to hire or keep an extended offer to an employee or a prospective employee.
So Ashley, you've told us about things they're not allowed to consider. Are there certain things that employers are allowed to consider?
Yes, if an employer does receive a background check that has a criminal history, they are required to consider specific factors when determining if an employee is still eligible for the position. So factors could be if the underlying crime was against property or against a person, how long ago the crime was. If we're talking about a conviction from 10 or 15 years ago, then an employer is not as easily going to be able to consider that when determining if a person is ineligible. Also, if the crime was expunged, or if they did enter into a diversion or treatment program, or if the employee does present specific information related to rehabilitation or mitigation.
So Ashley, we talked about expungements. We talked about Section 1203.4 dismissals. And we wanted to share with our viewers the actual procedure for getting this accomplished. Typically, a person would present a petition. You can do it yourself. Most people choose to have a lawyer because this is important and they want to make sure that this is done properly. But the law doesn't discriminate. If you present a petition that's properly filled out, that addresses everything correctly, just because you don't have a lawyer does not mean that the court will not consider it. But basically, you would present a petition in which you would allege one of two things. Either, number one, that you have been placed on probation and you have successfully completed your probation without violation. If that's the case, then the court is required to dismiss your case. When the court dismisses your case, they allow you to withdraw your plea of guilty or no contest. They substitute in its place a plea of not guilty, and they inform you that you are hereby relieved of all penalties and disabilities stemming from your conviction, with just a couple of specifically enumerated statutory exceptions. You can, in alternative, obtain the same exact relief if you show that even though you might have had some violation of probation, nonetheless, dismissal would be in the interest of justice. Dismissal would be in the interest of justice if you show, for example, that you have changed your life, that you have completely reformed. We typically will include with these petitions personal statement, letters that are character references, proof of employment, things of that nature. It is very common to have a person's record cleared. It's usually an exception and not the rule to not have these types of petitions granted. Obviously, it depends on individual facts and circumstances, but it's always a good idea to attempt to wipe that stain off your record and move forward in life. Lastly, we talked about some circumstances where you may be legally required to disclose that you've had a past conviction, even if you had it dismissed or expunged under Section 1203.4. Let's talk about some of those.
So there are limited exceptions. A vast majority of employees do not have to worry about these types of exceptions. They are specific to if you are applying for public office, if you are applying for law enforcement, if you are applying for state or federal license, or if for some reason you are applying to work for the State Lottery Commission.
Also, if you had your conviction set aside or expunged, and the conviction was, let's say, for domestic violence or some kind of offense that makes it illegal for you to own firearms or ammunition, you will not be relieved from that limitation by virtue of expungement alone. In some immigration scenarios, if you had a conviction that was dismissed or expunged pursuant to Section 1203.4, it might still count for some immigration purposes, so you always want to check with an immigration attorney when you're doing record clearance, just to make sure you're bringing the right type of motion, because that could play a big role. And then finally, if your conviction was for a DUI, the DMV has a certain period of time during which it can still consider your past driving record. And so just because you had something set aside in court under Section 1203.4 or expungement statute does not mean that it will not be used in the future by DMV for DMV-related purposes. But those are very, very minor exceptions. They should not stop anybody at all from seeking to clear their criminal record. And we encourage you, if you have ever had a past conviction, if you are now eligible to seek relief, by all means, please do that. Get it out of your criminal record. Wipe off that stain. You never know what opportunities life will bring you, and you do not want to be held back by mistakes of your past, mistakes of your youth. Now, as you guys know, at the end of almost every video, we like to bring you a short list of helpful suggestions, tips and tricks that you can do in order to improve your specific legal situation. And so Ashley and I are going to give you a very short list of suggestions for what to do if you have a criminal charge and are concerned about its impact on your employment or your future. Ashley, take us to number one.
So first, an employee should review any written employment policies that their employer may have, because a lot of times employers can have specific policies related to notice requirements if an employee has been arrested. So an employee wants to make sure they're always abiding by specific written employment policies, because that can be an easy loophole that an employer can use to terminate an employee.
Number two, please remember your rights as an employee. You may not lose your job simply because you got arrested. But if you fail to cooperate with the employer in the investigation, they can use it as a pretext to terminate you.
Number three, you want to make sure you're walking a fine line between oversharing when your employer is asking you questions and just providing need-to-know information specific to your job.
Number four, please be sure to discuss upcoming employment-related interviews with your criminal defense attorney. Your criminal defense attorney might be really concerned that you could incriminate yourself in the course of an employment interview, especially if your employer is somehow involved in a pending investigation.
Number five, if there has been a conviction, still remember that you have rights, and an employer cannot just unilaterally terminate you after a conviction. An employer can only consider certain specified factors with how the conviction relates to the business and the employee's specific job duties.
If you have had a conviction in the past, you have options in most circumstances for how to clear your record. You can file a petition under Section 1203.4. If you were successful on probation, you're going to get your dismissal automatically. If you have not been successful on probation, a creative lawyer could come up with other ways to show why a dismissal would be in the interest of justice. And once your conviction has been set aside, under most circumstances, you will be relieved of all penalties and disabilities stemming from your past conviction.
Remember that there are certain exceptions that an employee is required to disclose convictions to their employer, but remember that those exceptions are very limited, specific to applying for public office, applying for state or federal licenses, applying for the State Lottery Commission, or applying for law enforcement. But even if you do fall under one of these exceptions, just because you are required to disclose a conviction does not mean you will be unilaterally ineligible for a job. There are still protections that you have as a prospective employee to explain why you are able to still adequately do the job you're applying for.
Even if you have been arrested or convicted, do not despair. Be informed about your rights, be proactive, find and talk to a good lawyer. You can get help and you can get employment that you deserve. Do not let mistakes of your past hold you back from pursuing future opportunities. Be informed, be proactive, be smart, and stay out of trouble. Thank you very much for watching. I'm William Pernik. This is Ashley Cameron. Please click like, subscribe, join our channel. We look forward to bringing more interesting videos to you. Thank you.